For a Muslim, writing a will isn't just good planning, it's an act of worship. The Quran makes this clear in Surah Al-Baqarah, verse 180, where it says, "It is prescribed for you, when death approaches anyone and he leaves assets, let him make a just bequest for parents and close relatives." And again in Surah An-Nisa, verse 11, where it says, "Allah instructs you regarding your children. The male shall have a share equal to that of 2 females after any bequest you have made or debt that is owed." Our Prophet, peace and blessings upon him, turned that guidance into an urgent personal duty. He warned, saying, "No Muslim who owns anything to bequeath should let 2 nights pass without having his will written." He also said, "A person may do good deeds for 70 years, yet if he is unjust in his will, that final act seals his record with evil." You may be asking, why such urgency? In short, it's because a will protects 3 critical rights. First, the rights owed to people, which can include your debts, your promises, and even your children's care. It's best to leave nothing to chance. Second, the rights owed to Allah. This includes missed zakat, an unperformed hajj, kafara, or some other religious obligation you might have. By stating these types of things in your last will and testament allows your executor to have clear instructions on how to settle them. And lastly, the rights of your heirs. By following the guidance of the Quranic shares, we can prevent injustice. They shield minors, widows, and vulnerable relatives from being shortchanged. Practically speaking, an Islamic will is an act of mercy for your family. Without it, the United States intestacy laws decide who gets what, and those laws do not follow Islamic shares. Clear instructions spare your loved ones from court battles and confusion. And remember, Islam still allows you up to 1/3 of your estate for personal bequests or ongoing charity, so your wealth can keep earning reward even after you're gone. So, when you put pen to paper or fingertips to keyboard, remember, you're not just signing documents. You're fulfilling a Quranic command, heeding the Prophet's counsel, peace and blessing be upon him, and leaving your family a legacy of justice and peace. In this video, we'll learn how to complete the last will and testament template that the Islamic Association of Raleigh offers. This document helps ensure your estate is distributed according to Islamic guidelines while also meeting state mandatory legal requirements. Please be aware that this video is for informational purposes only. It is not legal advice. Always consult a qualified attorney to address your specific situation and needs, as well as ensure compliance with your state's laws. We'll go through these sections step by step. First, we will start with Articles 1 through 3, which may contain your personal declarations or instructions for debts and funeral arrangements. Second, we will move on to Articles 4 through 6, which detail how you'll distribute assets, name an executor, and finalize the will. Last, we will discuss Schedule A, which provides the specific Islamic inheritance formulas. These first 3 articles typically set forth your fundamental intentions, any funeral and burial instructions, and how debts should be paid. Carefully fill in any blanks, for example, naming an executor and a preferred funeral home, stating you want an Islamic burial, and clarifying instructions about outstanding financial or religious obligations, as well as the percentages of charitable contributions you want distributed. Article 4 is where you'll describe how the bulk of your estate is to be distributed after debts, funeral costs, and other instructions from Articles 1 to 3. As you see here, the template may direct any remainder to the Islamic Association of Raleigh or name other beneficiaries. If you have specific bequests to family members or charities, confirm whether you need to add them under these subsections. It's best to consult your attorney when deciding on what information to add and where to add it. Article 5 is where you will fill in the executor who will manage your estate and see that all instructions are carried out. If the first choice cannot serve, name an alternate. You also need to name a guardian for any minor children, making sure that person or persons are practicing Muslims. If both guardian choices are unavailable, then the will defers to the Islamic Association of Raleigh to appoint someone qualified. Now we've arrived at Article 6, the final section of your will. This section includes 2 parts. First, the separability clause, and second, the formal signing and witnessing portion. Think of this as your last step to make the will legally valid, so it is important to listen carefully to the instructions for each blank you'll fill in. The first paragraph of Article 6 reads like this. I direct and ordain that if any part of this last will and testament is determined invalid by a court or competent jurisdiction, the other parts shall remain valid and enforceable. This simply means that if a court later decides one part of your will is not valid, it doesn't invalidate everything else stated in the will. There are no blanks to fill in here. It's just a statement protecting the rest of your will if any specific clause is questioned. After the separability clause, you'll see a paragraph starting with the verbiage. I blank the testator, sign my name to this instrument this blank day of blank, and being first duly sworn. This is where you will start filling in the blanks. Let's break down the blanks to make it easier to understand. Blank number 1 reads, I blank the testator. This is where you will fill in your full legal name. This line identifies you as the person making the will, which makes you the testator. Blank number 2 reads, this blank day of blank blank. For the day, you will write the numeric day of the month. The following blank is for the month, where you will write the full month's name. The next blank is for the year, where you will write the 4-digit year. An example of this might read like this 14th day of August, 2025. Next comes the testator's signature line. After reading the paragraph, you'll see a line labeled testator. Here you will sign your name exactly as you wrote it on blank 1. This signature confirms you're willingly and voluntarily making this will. It is important to understand that you should not sign until you have your witnesses ready to watch you sign. Next is the paragraph for your witnesses. It usually reads, we blank the witnesses sign our names to this instrument, being first duly sworn. The testator signs and executes this instrument as his or her last will. Here's what they'll fill in. First, blank number 1 is for the witnesses' names. Each witness prints their full legal name on the lines provided. In many states, you need 2 witnesses. They should be individuals, not inheriting from your will, which makes them disinterested witnesses. Next comes the witnesses' signature lines. Here is where each witness will sign under the heading Witness. They might also date it next to their signatures if required by your state's law. Last comes what is called the presence requirement. All signings of this document must happen in the presence of a notary public, which means the witnesses will watch you sign, and you will watch them sign. Some states allow remote witnessing, but typically, you're all together. Some states don't require notarization to make a last will and testament valid, but most strongly encourage it so the document is self-proving in probate. Ask your attorney or check what the state of North Carolina mandates. Before they sign, confirm the witnesses understand their role, which means that they are verifying that you're signing voluntarily and that you appear mentally competent. Finally, there's a line that says something like, this document is made in blank number of copies, all the same and all original. One is with me, one is deposited with the Islamic Association of Raleigh, and one is with the executor. The rest of these blank copies are at blank. Here you will fill in these blanks as follows. In the first blank, state the number of copies being signed. This means the total number of physically signed copies. The second blank states how many are stored at other locations, like your safe, your attorney's office, a fireproof safe box, etc. On the final 2 blank lines, list all the locations where the extra copies will be kept. For example, at my bank safe deposit box or at my home office safe. It is important that your executor should know exactly where the document is kept. The court usually needs the original with all the signatures of the testator, the witnesses, and the notarization. That's it for Article 6. By completing these blanks correctly and having everyone sign in each other's presence, and ideally getting it notarized, you ensure that your last will and testament is recognized as legally valid. If any portion of the document is later challenged, the separability clause means the rest stays in effect. Once signed and witnessed, store your document in a safe location and consider giving copies to trusted family members or your executor. Always update if your life changes, such as marriage, divorce, or moving out of state. Now we move on to understanding Schedule A in the document. Schedule A is where Islamic inheritance rules are laid out for different family situations. Let's walk through each case so you can easily see which scenario applies to your family. Remember, Islamic inheritance can be complex, and every family is unique. These cases help your executor figure out how to distribute what's left of your estate after paying debts, funeral costs, and other instructions you have given in the document. If your situation doesn't exactly match any single case, or you're unsure, your executor should consult the Islamic Association of Raleigh for guidance. This explanation is just a simplified guide. For legal certainty, always consult a qualified attorney. Case number 1 applies if you have at least one son. This means that you might have one of the following: one son, multiple sons, as well as any number of daughters in addition to sons. In the case where there is at least one son, the inheritance is divided among the children so that each son gets twice what each daughter gets. For example, if you have one son and one daughter, the son's share is double the daughter's. If you have more children, the principle remains the same. Each son receives 2 portions for every 1 portion a daughter receives. You'll also see listed sub-scenarios like 1.b, that is labeled with wife. Here it states that the wife gets 1/8, and the rest goes to the children with the understanding that sons get double than daughters do. Then there is 1.c labeled with husband. Here it states that if the deceased is female, the husband might get 1/4, and the rest goes to the children. On to 1.d labeled with father and mother. In the case where the person's father and mother are surviving heirs, then they each get 1/6, with the remainder going to the surviving children. Remember, if you have a spouse, parents, or other relatives, each sub-scenario spells out exactly how to split the estate. Once those specific shares are taken out, the children share the rest. Case number 2 covers families where all children are daughters, meaning no sons at all. If you have one daughter, there are rules about what fraction she gets, plus how much a spouse or parents may receive. If you have multiple daughters, they share the child portion equally among themselves. For instance, sub-scenarios might say, if there's a wife involved, she should get 1/8 first, then the daughters share the remainder of the inheritance. In the case there's a husband, he should get 1/4, and the daughters share the rest, and so on. If you think your situation fits case number 2, but still isn't covered by the listed sub-scenarios, maybe there's a unique family arrangement, then it's best for the executor to contact the Islamic Association of Raleigh for help in determining the amounts to be given. Case number 3 applies if you have grandchildren from a son who has passed away, but no direct living sons or daughters of your own. In Islamic law, these grandchildren would effectively stand in for the deceased child. The rules mirror case number 1 and case number 2, but shift to these grandchildren. A grandson would receive double the portion of a granddaughter, similar to how a son and daughter situation works. Again, if your specific details are more complicated, your executor should consult the Islamic Association of Raleigh for help. Case number 4 is for people who have no children or grandchildren, and both parents, or at least one parent, is still alive. In this scenario, your estate typically divides between your father and mother. Each may get 1/6 or 1/3, depending on the presence of a spouse or other factors. If you're married but childless, your spouse also gets a share here. This will be addressed in case number 5. Case number 5 deals with a married person who has no children and no father or grandfather alive. So the main heir is the husband or wife. Typically, if the deceased was male, the wife might get 1/4 or 1/2, depending on other relatives. If the deceased was female, the husband might get 1/2 or more, again depending on who else is alive. Because there are no children, the spouse often receives a larger portion. Finally, case number 6 is a catch-all for any family situation that doesn't fit the first 5. This might include extended relatives like siblings, nieces, nephews, or unusual family structures not addressed in the other cases. If you land in this scenario, your executor should contact the Islamic Association of Raleigh for a proper Sharia-based ruling. Please be mindful that it is best to first identify which case best describes your family, and focus on the shares that are mandated by Islamic law. If any detail doesn't match, or you have unusual circumstances, or you are unsure what case example to follow, you or your executor should contact the Islamic Association of Raleigh for help. One very important factor to remember is that Schedule A kicks in only after you've settled debts, paid funeral expenses, and handled any discretionary bequests up to the 1/3 allowed by Islamic law. Everything left then follows these cases. That's the simple breakdown of Schedule A. Islamic inheritance rules can be detailed, but these cases guide how to split the estate in a fair, Sharia-compliant way. For full confidence, be sure to speak with a knowledgeable attorney and keep your last will and testament updated if your family changes. Don't let another night pass. Write your Islamic will today.